Professor Yoo, welcome back to Constitutional Chats. We are so honored to have you today with us for our 250th episode. We're going to be talking today about presidential powers and the role of courts, and if the courts have gone too far lately. I know we've got audience members who are excited to talk about yesterday's Supreme Court decision. So we're going to turn it over to you for some opening comments, and then we'll go to questions.
Thank you, Kathy, and congratulations on your 250th anniversary. I mean, not anniversary, 250th podcast. And it's a real pleasure for me to be on this one. Um, Let me start by addressing why there's a conflict between the president and the courts these days. First of all, this is not unusual. Our Constitution, unlike a lot of others in the world, has a separation of powers in which we have an executive, legislative, and judicial branches. And our founders, wanted those branches to fight. They were created specifically for conflict. Our founders didn't expect all the branches to agree all the time. In fact, they thought that would probably be unusual. The reason why is because they thought the more the branches fight, then the more our liberties are protected. The more the branches watch each other, the less chance for abuse of power. So that's one. Two, President Trump won the election in November. And like presidents who win a mandate, he has an agenda. His agenda is, I would say, to overturn the impositions made by the Watergate era on the presidency and to try to restore the presidency to something more uh, like something more like what the founders had in mind. An executive branch uh, that could act with speed and decision, effectiveness. Those are Alexander Hamilton's words. Alexander Hamilton said, energy in the executive is the leading definition of good government. The courts uh, have been wedded to the Watergate era and its reforms. After Richard Nixon stepped down, Democratic Congresses in the 1970s tried to take away presidential power and everything from war to impoundment to reducing the size of agencies to trying to spend less money. All the things Trump is doing are things that Watergate Congress tried to prevent. So it's not surprising that these challenges by President Trump to this older order are going to come up in court. Third point is that there are going to be some courts, lower courts, they're going to disagree with President Trump's agenda. People don't know it, but there are about 660, 670 federal district judges, trial judges, those are the district judges in the country. It's almost certain that some of them are going to disagree with President Trump's executive orders, who are going to think that he's gone too far. They're not all going to get it right either. That's why actually we have appeals courts above them. There are 175 appeals judges. They're 13 organized into 13 courts. And then, of course, the Supreme Court sits over all of them. And so the important thing is not, to me, it's not whether there's going to be a trial judge here or there who's going to try to stop President Trump's executive orders, but whether they do it in the narrowest way possible, not try to stop the whole government, not try to decide all the cases for the whole country at once, and then whether those cases can get up swiftly to the Supreme Court. Uh, you've seen that on display the last 2 days. Just yesterday, the Supreme Court intervened in the case of the Venezuelan gang members who were deported to El Salvador. A trial judge in Washington, D.C. tried to not just stop their deportation, tried to stop all deportations under what's called the Alien Enemies Act, a 1798 law that hasn't been used in this way before. And President Trump is certainly trying to use a unprecedented application of the law because usually the law is only used during declared wars. It's not limited by its writing to declare wars. It can also be used in invasions and what the statute calls predatory incursions. But this judge said no one could be deported under this law. It took a few weeks, but just yesterday, the Supreme Court said that that judge had gotten it wrong, that the case had been brought in the wrong court. It should be brought in Texas, where the actual deportees were. And that, right, and this is what and actually just this morning, and in another case earlier, a few days ago, the Supreme Court has also told lower court judges to stop trying to stop interfering with President Trump's ability to fire and downsize people in government. So, for example, a trial judge can say, this person who's in my courtroom has grounds not to be fired. But what a trial judge can't do is say, and no one in the federal government as a whole can be fired. That goes too far. And people were upset, I think, with the trial judges who ordered that. But as I've said, goes through the appeals court, goes to the Supreme Court, and the Supreme Court corrected that and narrowed it. This was also the case with the USAID. President Trump tried to reduce spending on USAID. A trial judge said no spending cuts at all. And the Supreme Court eventually overruled him and said, no, you can only order it narrowly. And just with the plaintiffs before you and the programs are challenging. Only there could a district judge grant some kind of relief. But in terms of nationwide questions, that's up to the Supreme Court. So yes, I guess the answer to the title of the program is that yes, there are judges who are overreaching, no doubt about it. But we have a system in place where, in an orderly way, the Supreme Court is going to curb those excesses. And so I don't think that it's time to talk about things like impeaching judges or defying judicial orders. In fact, President Trump has already said that there will be no defiance of judicial orders, and I think that's very wise on his part. As far as I know, only one president, Abraham Lincoln, has ever defied a judicial order, and that came at the start of the Civil War, where the author of Dred Scott, Chief Justice Roger Taney, ordered him to release Confederate prisoners of war at the very start of the war, and Lincoln refused. And I think Lincoln acted properly there, but we're nowhere near any kind of situation as bad as that. So I think that, yes, there are trial judges who are overreaching, and you're going to read about more of them in the papers. But we have a system where we have a Supreme Court. Half of the conservative majority on the court has been appointed by President Trump in his first term. And they will eventually make sure that those trial judges don't overstep the bounds on their power. So thanks for the invitation to come, and I look forward to hearing your questions.
Well, thank you so much. And that was such a thoughtful analysis, and I think really clarifies a lot of what we've been reading in the news about these various decisions. And I'm going to turn it over to Janine.
Hello there. I'm so glad you're back on the show. Thank you for your graciousness of spirit here
It's
to
great
come
to
in.
see you or hear you.
I know. Sorry, I can't be on today. I'm traveling, so I'm so sorry. But yes, thank you so much. And that I agree with Kathy. That was thoughtful. And I have this is going to be a little bit a redundant of a question, but you have the executive branch, and then you have one judge. First of all, I'm curious about who filed the complaint with the judge in the wrong state. Because if the Supreme Court said you're in the wrong state, it happened in Texas, who did file that complaint? How does that even start to happen? And what state did they go to? And how come they couldn't figure that out? It's interesting to me. That's question A. And question B is, it is a little disconcerting. And is it really true? And I guess it is, that one federal judge can overturn a president, like one man or woman who might, obviously be politically inclined. That's interesting to me. It went all the way up to the Supreme Court, but federal judges can really overturn and just cancel out something a president's doing. I find that really interesting. I thought I was hearing some talk that maybe that wasn't the case. So those are my two questions right up front.
Great, both excellent questions. So with the first question, the people who filed the suit here were lawyers for, I think, six of the Venezuelans gang members who were sent to El Salvador. And they, like any lawyer, are engaged with what we call forum shopping. Forum shopping is not as sexy as it sounds. I mean, it's not like real shopping. Forum shopping is when your lawyers try to find the most favorable court to file in. And so they tried to concoct an argument where they could go to Washington, D.C., where the trial judges and the appeals court have a lot of members appointed by Presidents Obama and Biden. But, as the Supreme Court just made clear yesterday, uh, they misread the law. Usually, you have to file the lawsuit where the detainee is. And they were last in the United States in Texas. Now, they don't want to file in Texas and Louisiana. They don't want to file in Texas and Louisiana because the Court of Appeals there, that's just called the Fifth Circuit Court of Appeals, is generally thought to be the most conservative appeals court in the country. So these lawyers for the detainees were trying to, play a game to try to move out of the place they should be to somewhere they hope they would get a, more favorable outcome. But now we know, because of the Supreme Court, that won't work, that you have to bring these cases where the Venezuelan gang member was held before they're sent out of the United States. Now, it should be clear also that the Trump administration said to the court that we're not trying to deprive anyone of due process here. In fact, we agree that any of these gang members, when they're sent out of the country, they have a right to a hearing, but it has to be in the right place. On the second point, so it is true that in a properly brought lawsuit, that a federal judge can block a president's executive order. In fact, a federal judge can block an act of Congress if they think it's unconstitutional. They can't block a law or an executive order just because they disagree with it, disagree with the policy. It has to violate the Constitution. That's not unusual. That's something that we've had in our history since Marbury versus Madison in 1803. But what's unusual here, what's been going on this last few months, is that some judges have said, again, it has to be in the right case, in the right place, with the right plaintiffs. So judges can't go around saying, oh, I just dislike that you're not giving out grants at USAID, so I order you to stop. It has to come up in a lawsuit by someone who's injured, and they have what we call cause of action. They have a legal right to sue. And you can't, and this is what the Supreme Court's trying to make clear today and last week. And you can't use that one case that you have before you as a trial judge to try to run the government. You can't say, and therefore USAID must give out all the grants for everybody, even people who didn't sue. That's the difference. And I think that itself is a major limitation on the power of the courts themselves, and which the Supreme Court is trying to force these trial judges to live by.
Are you saying that? Let me see if I'm following you correctly, and forgive me if I'm not. Six. So six of the lawyers for six of the gang members that were supposed gang members that were taken away. Six lawyers filed for them, and the judge tried to say you have to bring those six people back. Instead of saying you have to bring those six people back, he said you have to bring all of them back. Is that what you just said that he was trying to do?
Yes, that's the mistake that the judge made. And that's been going on in all these cases. For example, just earlier, someone sued and said, I can't be fired. I have a civil service job. And the judge there said, well, not only that, but I order the entire federal government from not firing anybody. Or I order Doge not to fire anybody, not just this one person, but anybody at all. And the Supreme Court is trying to make clear federal judges don't have that power. They can only intervene in the individual case. If they start saying the whole program, the whole agency, the whole government, then judges really are trying to run the government rather than the president and Congress.
That is very interesting piece of knowledge that you just don't get in the news necessarily or in anything that you read. That six people filed for six of the individuals that were taken, but they tried to make it for everyone that was taken. That's an overreach. That's what you call an
Hmm.
overreach, right?
Hmm.
Really, really interesting. Okay, so my final question before I toss to my fellow panelists is it is a conundrum and confusing to a lot of Americans that someone that broke into our country, that that came here illegally, that that maybe surreptitiously went around the border, and you know, they're not even American citizens, and they broke our laws to get here, and they came in defiantly and surreptitiously, and they're here, that they would get the constitutional process of rights. That is confusing to people. So I'm not necessarily speaking for myself, but I hear it a lot when people say, "Why? Wait, what?" I mean, it does seem to be a conundrum that they broke the laws. They're not here legally. They're not Americans. So why do they get to abide? And I think we discussed this before, and there was a reason for this, but I have forgotten since then. So what's the reason that these people would be able to have the same rights as an American citizen?
Well, part of it is the constitutional text in the 14th Amendment, which is what grants most rights against states. And then the Bill of Rights itself, it doesn't grant the rights to citizens. It often says to people or persons. And so the courts have said, therefore, there's no distinction. So that's one. But I also want to say, more importantly, that the illegal aliens may not have exactly the same rights. So, for example, yesterday the Supreme Court did say that even these illegal aliens, before they're deported, they have a right of due process. But the court didn't say exactly what that would look like. And in general, we give illegal aliens some process, but we don't give them anything like a full criminal trial. We offer a much faster, expedited process because the goal is to remove them from the country when they're here illegally. But there's an important case that's heading its way to the Supreme Court involving the United States' decision to expel one of the leaders of the protests at Columbia University in favor of Palestinians in the Gaza war. And his claim is I'm being, excuse me, deported because of my free speech rights. And so you can't deport me just for exercising my constitutional rights. The law says that the Secretary of State is allowed to deport any alien, legal or illegal, whose presence here interferes with our foreign policy and national security. And so that of course does not apply to citizens. And so there already in the law is a difference in the way citizens and aliens are treated. That is going to go to the Supreme Court, I think, and we'll get a definitive word. But I just want to make clear already aliens don't have the full set. They have some rights, but they don't have the exact same rights as citizens do.
Very interesting. Really, really interesting to know. And I guess if we wanted to change that wordage, we'd have to do an amendment to the Constitution, that says these
Hmm.
rights are for citizens only, so to speak. But interesting. Okay, wow, you're fabulous. Thank you so much.
Thank
This
you.
we've learned so much and cleared up so much in just the first 25 minutes or 25 minutes here. Thank you, and I'm going to pass to my team. Appreciate you, and really appreciate that you came back on for us today so much.
Thank you, Janine.
Hello, Mr. Yu. This is Joel Gilbert with Constituting America. Thanks for your opening and everything you discussed with Janine. It's been great. Can you just tell me if I've got this part right? So, based on everything you've said so far, you'd say that there are judges who are overreaching, but the system is succeeding in taking care of that eventually, like in process of the way the system's working, that is working to take care of the judges overreaching.
Yeah, I'd say so. I mean, so far, uh,
Okay.
President Trump has been winning more often than losing at the Supreme Court right now in the review of these district judges. It may be the case that the Supreme Court rules against President Trump at some point. I'm sure they will eventually in some case. No president has a perfect record at the Supreme Court. But the point of the court is to make sure one of the main purposes of the Supreme Court is to make sure that the trial judges operate properly within their powers. And when you have 675 trial judges, they're not going to be perfect. If they were, we wouldn't need appeals courts or a Supreme Court at all. So they make mistakes all the time. And so that's why we do have this whole system of appeals above them to make sure that when they do make mistakes, that they're corrected. And so far, I think that's been going on these last 2 weeks.
Now I have a question. I want to bring up individual cases or individual district judge rulings particularly, but um I know that judges in general enjoy protection from recourse to their rulings, whether they're appealed or not. There may be recourse professionally, but as far as like, they're not going to have criminal recourse for in general for their rulings that they make. When we see individual district judges make rulings that, if it could be proven, were simply political, do you think that the system needs a correct for that besides the appeal process, which may take a lot of time when the district court's rulings could hurt the country in the meantime, and impede the president's power that in many cases has been deemed that he had that executive power by the Supreme Court. So I guess the question is, do you think that our system right now needs to look at judicial protections or look at rectifying when judges do overreach more of a recourse?
So we should recognize that judges are different in our system. They have their jobs for life. Their salaries can never be cut. So the founders did already try to insulate them from political pressure, from people retaliating against them because they don't like their decisions. On the other hand, we have the impeachment clause. And so take an extreme version of what you're suggesting. Suppose a judge took a bribe to decide a case a certain way. That judge could be impeached. That would meet the standard for impeachment, I think. If a judge were not even deciding on the law, but just deciding things because they're a Democrat or Republican, you could probably impeach them, although it would be very hard to prove. But what I think the impeachment clause is not there for is to remove judges because we disagree in good faith with their judgments. Uh, it's possible for judges, it's certainly possible for us to disagree with judges, and judges disagree with each other all the time. And so uh, this was actually something that was fought out under the Jefferson administration. When Jefferson came into office, at that point, every judge had been appointed by the party of Washington and Adams. And there were people in the Democratic Party then who wanted to start impeaching some of them. And the Congress impeached a justice, Justice Chase. And he was only acquitted by one vote in the Senate. But ever since then, our system has operated under the norm that we would not use the impeachment clause because we disagree with the substance of the decisions. Now, if someone's acting outside of that, then I think that would be appropriate for impeachment. But I have not seen that so far. I don't feel that the judges that have been deciding against President Trump here are taking any bribes or acting unethically or improperly. They just disagree. And that I think is not what the impeachment clause is for.
Interesting. Yeah, if we, I would imagine that although there could be a lot of inefficiency in the system, some of that by design, and although it could be very frustrating to the executive powers, that the alternative is what you suggested, that judges are impeached across the board when the opposite party wins elections. Um, so the system itself would that would hurt the system more than the judges frustrating the executive's powers. Is that what you'd say is correct?
Well, keep in mind that the reason we give judges all these protections is because we want them to stand up to the majority. When judges say something, someone has a right to speak, or someone has a right, to protest or to exercise a minority religion. They're doing it because usually there's a law the majority has passed to try to stop them. And so we have a system we built that favors individual rights against the majority. And that's why we gave judges this special protection. So you could have a system where judges are more subject to some kind of process of removal that's easier than impeachment. But then I think that you also undermine the ability of those judges to stand up to the majority on the basis of for to defend individual rights when we would want them to.
Do you think that there are any um, policy changes or changes that Congress could make, or small, big, any changes that we would want to see in the system right now, from particularly talking about cases that reach district courts and then are appealed and reach all the way to Supreme Courts regarding to the president's executive actions? Do you think that there's any improvements that could be made, I guess, from the inside or outside the system? So from the inside, meaning actual change of some form of the system itself, and from the outside, political pressure of some kind, or yeah, political pressure that can be. That's a pretty broad way of defining it, but that's how I'll define it for the question.
So I think Congress could help by doing some of the things I talked about that the Supreme Court could do, such as making clear that trial judges don't have the power to stop the entire government from pursuing a policy. Uh, and of course, everyone's free to criticize and make their views known to the court. And I think judges have this kind of institutional independence, so they shouldn't respond to it. They should just decide the cases as they see fit and ignore the politics of it. Uh, I don't, I don't think so far there's any need for change. The Supreme Court is actually acting very quickly. I mean, President Trump hasn't even been in office for 100 days. And I think the Supreme Court's probably decided 4 or 5 cases now. That's incredibly fast. About his executive orders. It usually takes years for the cases to get to the Supreme Court. So I don't see that there's any need for changes. I think the system is actually operating well.
One
Now,
more.
President Trump is driving. Excuse me.
No, you can finish. I just
Thank
had
you.
one more
So
question. I thought you were done. I was just starting to ask the last one.
go ahead. Go
Okay,
ahead.
last question. Do you think that there's, just in your opinion, are you concerned about any of the rulings on the opposite end, that you think that the Supreme Court uh, gave the executive too much power in any of those five rulings um, that they have ruled so far?
No, in these cases so far, I think that the trial judges have gone too far. And what the Supreme Court's doing is restraining them and saying, narrow your rulings. Be conscious of the limits on the judicial power. Stop trying to issue these nationwide injunctions, that govern whole agencies or every employee in the government. I've not been too concerned so far of what the Supreme Court has done with
All
regard to
right.
executive power.
Thank you very much, Mr. Yu. I'm going to pass it to Wyatt.
Yes, this is Wyatt Hensley here. Thank you, Professor Yu, for coming on today and just really giving us a great description of everything that's been going on. So one of my first questions was talking about judicial activism. If you could, I've heard a lot of people discuss that in some of these cases, they believe that the judges are exercising this judicial activism. So I was wondering if you could kind of explain what that term means, as well as judicial restraint.
Well, these terms tend to get overused, and so there's probably no clear definition. You could probably say anytime that a judge exceeds their powers, they're engaged in judicial activism, and that judicial restraint maybe this is the proper understanding of the role of judges in the constitutional system, that they should, keep their decisions just to the cases before them and interpreting the law and the Constitution, but they should not get into policy. That they shouldn't stay out of, is it a good idea for USAID not to be giving out billions of dollars? All they have to do is ask, does the president have the authority to stop USAID from giving out billions of dollars? The activism versus restraint also is not really anymore tied to any one ideology. I mean, there are conservatives who would like the courts to be much more active in defending property rights, for example, or rights of freedom of exercise of religion, or the Second Amendment. Uh, and right now, a lot of liberals are ones saying we want judicial restraint because a lot of the existing precedent on the books still comes to us from the Warren Court, which favors the progressive view of the world. And so they don't want the cases to change. It's more often, I think, liberals who are actually demanding judicial restraint these days. So I think the terms are so elastic that they don't really help us understand what's going on right now.
Yeah, yeah, very interesting. You had touched on this, excuse me, briefly, about the United States Supreme Court taking up these cases rather quickly, as you were saying that President Trump hasn't even been in office 100 days, and they've already decided on some of these cases. I was kind of wondering if you could talk about the process in which they can issue these temporary rulings and how they can decide on these cases rather quickly.
The reason why is because a lot of these judges at the lower court level are issuing um, what we call, I mean, they have a variety of names, temporary restraining orders, preliminary injunctions, their initial takes on the case before a whole trial is held, for example. And so, in the case, for example, of the Venezuelans that we've been talking about, the trial judge in Washington ordered the planes to turn around, wanted everybody brought back, because he said, if I ultimately decide that the deportations are illegal, then they should all still be in the country. If you send them out of the country, it'll be too late. And so a lot of these trial judges are saying, I want everything frozen. That order to freeze everything, which is sometimes given immediately, sometimes in a day or two, not the year that it would take for a trial. When that's issued against the government has the right to go to the appeals court and to the Supreme Court in a faster way than normal. And so that's why the Supreme Court has been able to hear these cases so fast.
Yeah, and are these permanent decisions too, or is some of these temporary decisions from the Supreme Court?
No, you're right. A lot of the Supreme Court decisions themselves are temporary. So, for example, in the case of the Venezuelans, the court did not actually address whether the Alien Enemies Act can be used outside of a declared war. All they said was this case was brought in the wrong place. It should be brought in Texas or in New Orleans. Uh, Once it's brought there, start over again, and then ultimately these questions will come up to us later. So even that has a temporary quality to it.
Hmm. And then also wondering about injunctions too. You've been talking about that as well. Have injunctions been increasing over the couple years, past few years actually? Um, why, if there is an increase, why would some judges increase that?
Well, injunctions actually refer to any time a judge gives an order saying don't do something or do something. But I think what you're referring to are nationwide injunctions,
Mm-hmm.
which is this practice which the Supreme Court's, becoming very suspicious of, which is where a judge takes the one case before them and then issues an injunction that affects the whole country or the entire government. And those have been exploding under Trump. In fact, I don't think there are really many examples of these before the 1970s and 80s, but I think the statistics show that under Trump's first term, there were more than there had ever been before. And it's clear now that Trump's second term is going to break the record that he set in his first term. So I think it's important that the Supreme Court intervene or Congress intervene to make sure judges don't think that they have that power.
Yeah. And then another question that I was wondering too, if the Supreme Court issues a decision, is there anything that can be done, maybe to reverse it? Because you were saying some courts get it wrong, and obviously Supreme Court can also get it wrong. Is there any way to amend that decision?
Well, if it's an interpretation of the Constitution, then the only way to change it is for the Supreme Court itself to change its mind or for there to be a constitutional amendment. But a lot of these cases that we're talking about don't really involve interpreting the Constitution. They involve interpreting or answering the question whether Congress gave the president power to do what he wants to do. And so a lot of these cases, what could easily happen is that Congress could just pass a law approving what Trump's doing. So take the example of this Doge committee. If Doge is going to sit there and say we should cut spending here, we can downsize the government there, we can fire these employees, those are all things Congress can do immediately if it wants to by law. And if the courts eventually say Trump can't do this, it will just be because Congress didn't give President Trump the authority to cut spending. Usually spending is up to the Congress, not the president. The president just carries out the spending that's set by Congress. So, yeah, Congress could easily, for example, make Doge completely legitimate, could easily approve all the spending cuts, firings, and downsizing that Doge is recommending if it wants to.
Hmm. Yeah, well, thank you for your insightfulness and expertise on this issue. I have seen that there's a lot of audience questions, so I'm just going to go ahead and pass it right back on to Kathy. Thank you so much, Professor Yu.
Well, thank you, Wyatt. And before we go to the audience questions, I'm going to bring Janine back in with another question.
Yes, I'm being greedy, and I don't want to take up too many of the audience questions here, so we can make this quick. I understand what I love about our Constitution are the checks and balances. The checks and balances, the checks and balances, and so far, the Supreme Court's making the right decision of keeping these federal courts in check. But what if what if they didn't? And you had a federal court, a federal judge, instead of saying bring the six back, bring all of them back. You have no right to send these, gang members out of the country, bring them all back, which is not according to precedent or procedure. And the Supreme Court validated that. Then you're really up a creek, right? At what point? And I know that impeachment is for things like treason and more insidious type of things, but that judge surely knew that six people had filed and he was really only responsible for those six people. So I know it's not impeachable. And we got lucky that the Supreme Court slapped him on the wrist and said, you can't do this. But I mean, is that not a little bit impeachable? I mean, he knew differently. So how do you keep those judges in check? What if the Supreme Court didn't do it? What other kind of options are there to keep a judge that's trying to turn six people into 600, and kind of take over the presidency here? If the Supreme Court didn't do it, what are the other resources if not impeachment?
It's a great question, and this is, something, of course, that has challenged presidents for 200 years. You mentioned Abraham Lincoln trying to figure out how to get Dred Scott overturned, or FDR, who tried to pack the court. Presidents have really struggled with this question. So I think it's a very good question because no one's talking about them, but the answer I think is Congress. You'll notice that Congress is not really getting involved in any of these fights, but under our Constitution, it's really Congress that has the power over immigration. And so if Congress wanted to give the president the ability to kick people out of the country faster, to especially these dangerous, violent gang members, Congress could change the immigration laws to do that. Uh, Congress could cut funding for all these excessive, uh, workforces and these unnecessary federal agencies that DOJ is discovering. But Congress has been missing, I think, in part because it agrees with President Trump right now. And should Trump win in the courts, then they won't have to get involved. But I also think President Trump would be wise to go to Congress and say, I want you to approve everything I've done. And there's an important lesson in this about the executive power in the presidency, because the presidency, President Trump can do all these things he's doing, but a Democratic president can come right in after him and undo all of it unless Congress passes laws codifying it. So, right, President Trump could say, I'm not going to really let USAID do very much. But President Kamala Harris could come back in 4 years and say, I changed the policy. Now USAID is back at the front. But if Congress passes a law zeroing out USAID, there's nothing the next president can do about it. So I think it's a good question. And we should ask, what's Congress doing in all this? Shouldn't Congress get involved? Because I think they do agree with President Trump for the most part on these policies.
Yeah, that's a great answer. Of course, it doesn't reprimand a federal judge who knew the difference between six people in the entire plane, right?
Yeah, I mean, I wouldn't use the impeachment power for that. I think he, uh, got reversed by the Supreme Court. For a federal judge, that's probably the most embarrassing thing that can happen to you.
Mm, yeah. Well, I'm just thinking, what if that hadn't happened? What are the other resources? What if it was a liberal court and it was the other way around? But no, I'm not
Yeah.
impeachment happy. I'm just trying to think, how do you what are the other resources?
I mean, the
But
other thing that's happened, which takes a lot more time and effort, is you have to change the membership of the Supreme Court. That's why, nominations and confirmations of the Supreme Court is so important. So essentially, what you describe is what happened during the Warren Court period, where the Supreme Court did issue, I think, many decisions that were not based on the text and original understanding of the Constitution held by the founders. And it really took 30, 40 years of uh, Republican presidents saying, I want to change this. I'm going to only appoint conservatives to the court. And it's interesting. It's really President Trump with his three appointments in his first term that really made that happen. But it takes, decades in a way to control the presidency when these Supreme Court vacancies occur, to pick the right nominees, get them through the Senate, make sure they have the right judicial values in mind so that you can ultimately get the court to change its mind.
mhm. Really, yeah, terrific. Thank you so much. I'm going to pass now to audience questions. I won't hoard any more time. Thank you, Kathy.
Well, thank you, Janine and Jewel and Wyatt and Professor Yu. Thank you. This has been a really enlightening episode, and we do have a lot of audience questions. Before we go to them, we want to thank our teachers, our educators, and our students who are watching with us today. We want to thank Cherie Stiegel, who's watching with students, and Kenyon Wanos, who's a homeschool student watching. Finn Bestland is a student watching. Professor Klinger is a great educator who's watching. So if you are a teacher or students watching today, please let us know in the Q&A, and we'll try to give you a shout out before the end of the program. We also want to thank our listeners on Las Vegas's KKVV 1060 AM on the radio dial. KKVV airs Constituting America's Constitutional Chats on Mondays at 6 p.m. Pacific. So thank you to everyone in Las Vegas listening. Professor Yu, we're going to start with Lewis White, who first just has a nice comment hearkening back to Constituting America's 250th episode today. He says lots of 250th this year. 250th anniversary Declaration of Independence, which of course is next year in 2026. 250th anniversary of establishing the Marines, Navy, and Army. So Thank you, Lewis, for the 250th tie-ins here to our anniversary episode. But Lewis also has a question. He says, why is it that the Supreme Court feels it has to wait to be asked to comment or rule?
That's an excellent question. It's because the Constitution's text, when it creates the Supreme Court, says that the Supreme Court's power only extends to cases or controversies. And so, because of that, the Supreme Court has said we can only intervene when there's actually a case, when there's a lawsuit. In fact, it's interesting. In one of the very first acts of the Supreme Court, when the French Revolution occurred, the Washington administration asked the Supreme Court, without any case, what are the legal standards for our Treaty of Alliance with the French? Do we have to come to their aid? Has the revolution changed their government so the treaties are now inoperative and so on? And the Supreme Court wrote a letter to President Washington and Thomas Jefferson, and they said, our power is only to decide cases. We can't actually get involved with any other questions, and we can't function outside of the decision of a single lawsuit. Notice it's that same interpretation where, I'm then therefore saying, and you can't have nationwide injunctions either. Judges have to only decide the case that comes up before them in a lawsuit. They can't then say, and because of this case, I'm ordering the USAID to spend all its money.
Fascinating. I never have heard about that letter before from the Supreme Court to President Washington. That's really interesting. Andrew K. says, I would be interested in Professor Yoo's reflections on the pre-Watergate imperial presidency of Lyndon Johnson and the denigration of the presidency during Johnson's closing years in office.
Yeah. So one thing I think Nixon did say during Watergate is that he hadn't been doing anything that his predecessors, LBJ and JFK, hadn't done either. And so I would describe the presidency as it was before Watergate as giving exceptional amounts of discretion to the president and trusting that the presidents would use that power properly. But, as the questioner points out, there's a lot of potential for abuse. LBJ or Nixon did engage in some abuses of their presidential power to benefit themselves politically. And so what Watergate tried to do is take away all these powers from the president because we were so worried about abuse that we ended up making the presidency itself less effective.
Okay, very interesting. And then you've mentioned injunctions, and Jay McGonville says in the entirety of the Bush, Obama, Biden administrations, 5 terms, 20 years, there were 32 nationwide injunctions issued. In the first 2 months of the current Trump presidency, there have been 37. 64 were issued against Donald Trump in his first term for a total of 101. In the entire 20th century, there were 27. And by the way, thank you to Jay. He serves on our board. And Jay, we're so happy and appreciative of you being on today and for your question. Do you have any comments on that?
Yeah, those numbers sound about right to me, that there used to be almost no nationwide injunctions. They started up, I would say, in the 80s and 90s, but really, really came to the fore in the 2000s, and that they've just been much more heavily used against Trump than other presidents. And that I think that I think that nationwide injunctions are not legal. I don't think the judges have that power. And the Supreme Court could put an end to it. They've got several cases before them right now where they could address it. Several of the justices have said, both conservatives like Justice Thomas, who I clerked for, or Justice Kagan, have said that these nationwide injunctions are not rooted in the Constitution. And it's suspicious when a judicial power is used almost wholly against one party and not the other party.
Exactly. And Julianne Smith asked a question that actually follows your answer really well. She asked, with President Trump winning in this most recent Supreme Court case, do you think that will send a strong enough message to the lower courts that they need to back off and establish greater restraint in their rulings outside of their powers as SCOTUS has ruled? Or do you think we'll keep seeing these rulings from the lower courts that are broad?
There's you remember that these judges have lifetime tenure, permanent salary. They're deliberately insulated from politics, so these judges, not a lot affects them. They're not going to be impeached for the most part. But what they don't like is being humiliated by the Supreme Court.
Mm-hmm.
And I think that, for example, the judge who tried to force to stop USAID budget cuts, I think the Supreme Court sent him a pretty stern message, and I think he was embarrassed. I think hopefully you'll see child judges be a little more careful about deciding their case instead of just issuing, arbitrarily these nationwide injunctions. But there's no way to force them unless the Supreme Court sits down and says there are no nationwide injunctions, which it hasn't done yet.
Okay. And then Mark A. Beer asks, is the proliferation of lawfare a result of the content of today's legal education?
Uh, I don't think so. I mean, I'm a professor at a law school. Um, Law schools are, pretty progressive places. I don't know if that itself has led to lawfare. I attribute the use of, by lawfare, I mean using the court system for sort of blatantly political reasons. And I think of more the use of prosecution against a former president, try to stop them from entering the election. That was unprecedented. I see lawfare there more as a sign of the partisanship that we're seeing in the country, a sign of the polarization that certain people in both parties are willing to do anything to win. And so it was almost inevitable they would start turning to legal tools rather than just political to fight.
Well, thank you. And this has been a really educational episode. And we just thank you so much for your time today. We know you have to get to another appointment, so we're going to end a little bit early today, but we want to thank you for your time and being with us. And we also want to thank our audience, and we want to remind everyone to come back next week. We're going to have the former Speaker of the House, Newt Gingrich, on. And so we are really excited to hear from Speaker Gingrich. And Professor Yoo, we just thank you so much again for being with us. And Janine,
Thank
any
you. It's
closing
my pleasure.
comments?
Oh, I just want to thank you, Professor. Thank you so much. You're really a jewel, a treasure, an American treasure. Thank you so much.
Well, we have two jewels on the podcast then.
Jewel's a jewel too. So is Wyatt. So is Kathy.
Well, thank y'all so much. Have a great rest of the week.
Thanks, Professor.
Thank
Bye.
you.